Good evening to all the participants who have joined us this evening. Um, the topic is quite interesting and also very important. This evening, we plan to cover the not only the certain direction, the way it is sort of articulated, but also in detail the implications for the industry. Of course, all of us are still evaluating the total implications. We are still receiving industry feedback. But the entire purpose of this conversation is we would definitely like all the participants to also send us their queries. We may not have all the answers because it's quite new, and the government is also likely to issue an FAQ in this regard, but we would definitely love to have your concerns and feedback so that we can collate and present it as an industry feedback to the certain. Before we begin, I would like to introduce our panel members. I'm Gauri. I head the overall technology media telecom practice, but also focus on data protection, cybersecurity, and the like. We also have a veteran, Mr. Milind Mundankar. He is a go-to person for our team in the firm because he's a technical person handling cybersecurity and data protection issues from a technical. We have Aparna Gaur. She's a senior member of cybersecurity and litigation team, also focuses on IP data and overall TMT as well. And we have a new member of our team, Anirudh. He also sort of comes with a solid background on the TMT and also has been working on this cybersecurity issues for some of our clients. Let me give an overview of what we plan to do today and dive into the topic immediately. As you may be aware, the Information Technology Act came in the year 2000. There were several amendments and very substantial amendments made in the year 2008, which were effective in the year 2009. And one of the provisions that got inserted in that amendment is Section 70B. Section 70 essentially established what we call as CERT in now. However, of course, it is only in 2013 that the rules were issued under Section 70B, and we had a certain established. Certain is a body that acts under the aegis of the Ministry of Information Technology, which in short is called MeitY. It has a director general and other officers, and also has an advisory board. Interestingly, it is a body that works 24 by 7, uh, obviously because the kind of issues it handles. Basic functions of certain essentially are, collection and analysis of cybersecurity incidences, assisting the industry in, responding to cybersecurity incidences, also forecasting and alerting the industry about the incidences, taking emergency measures, etc., in relation to the cybersecurity incidences. And it also is supposed to issue guidelines, white papers, etc., for an overall guidance. Now, let us understand from a jurisdiction perspective. Of course, we are talking about cybersecurity incidences in India. There could be a confusion as to when foreign parties are operating in India, whether or not they are required to make cybersecurity reporting, and we'll deal with that aspect in a bit. But I thought I'll just give an overall perspective as to the purpose and the working of the certain as a body. We have had some of the clients, undertaking reporting to certain under the 2013 guidelines. When the 2013 rules came in, there wasn't as much furor as we see today, and there is a reason for that. Under those guidelines, the obligations or the expectations of reporting were not of the nature that are given by this direction, and we will see the difference here. But before we get into the specifics, I want to deal with a couple of legal aspects that as a legal community we should be sort of looking into, and maybe even making a relevant representations to the government, is that if you really see the hierarchy of the act and the rules, the act of course comes at the top. Then you have the rules, for example the 2013 rules that were introduced in 2013 under section 70B. And then this is a direction. Now what is this direction? If we see subsection 6 of 70B, certain has been given an authority to issue directions. The question is, can this direction be of a rule making nature? Because if you really see the rules that are issued under section 70B, those can be issued by the central government, and of course it needs a parliamentary scrutiny technically. Whereas this direction is simply an executive action by a body established under section 70B. So the question is, can a direction really supersede the rules, or even amend the rules, and be of such an overarching nature, which actually if you really see, is in at places in our view even ultra virus the act, right? Forget the ultra virus the rules, but even ultra virus the act. So that is where I feel, somewhere there the direction, for all may get challenged by some stakeholders. But while the direction is still in effect, let us understand the implications. So under 2013, you always had a reporting obligation, but this reporting obligation has been amended, and we'll discuss that. The second thing is, information maintenance and provision of certain information. Again, 2013 did have something, but there is an expanded obligation. And then you have KYC requirement, which in my view is really, really, sort of overarching requirement, and doesn't fit into the realm of the intention of subsection 6 of the act. Because in my view, uh, the direction in could be only of a nature which is specific, say, to a cybersecurity incident that a certain can issue, and not a general direction of this wide nature. So with that background, before and let's not undermine the importance of this development in the context of what we saw last 2 years. We are not undermining the importance of cybersecurity at all, but we want to see the proportionality as we go along in terms of reporting. So before we get into the specific of the direction and the impact, Milind, we would really want to understand from you, since you have been observing the type of incidences that you have seen in the last 2 years, especially during the pandemic when the entire world had to work, on the on the net, or digitally. What is nature of incidents is number one, and you could also explain the type of impact of those incidences. So one is the incidents, right? But a consequence of that, is it more of data breach? Is it more of security of the network? What is the nature of the impact that you have seen in last couple of years?
So, Gauri, this is, I mean, we all know that, from the past couple of years, we have seen cybersecurity, specifically in India, has jumped from those 37th position to the 10th position when it comes to cyber attacks. So it's increasing at a very alarming rate, and there have been over 15.5 million cybersecurity incidents which has taken place, out of which more than 1 million alone was in the year 2020. So the incidents are rapidly increasing, and some of these common cyber attacks which most of us have been facing which has taken over the cyber world today. That's I would say the first one that would rank at the top would be obviously the phishing attacks, because we've seen that 86% of the organization had at least one user who's been connecting to the phishing site. And it's like sending those massive phishing emails to your network, and the 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 damage is very massive when it comes to all this thing, because it, with the malwares and everything else that they install, they not only steal your data, sabotage your systems. It can hit organizations of any size, whether they are small or big. But then they also they can also go to the extent of stealing your IP, intellectual property of your organization. In fact, the recent Russia-Ukraine war has, opened up some, you know, amazing amount of attacks, and it's all multiplied to an extent where there have been so much of advancement on that front, that even when it comes to the traditional phishing attacks which used to happen earlier, they have come up with this micro backdoor kind of phishing attacks, which specifically focuses on the government organizations and all those things. So one is phishing attacks, which is when it comes to the damage, it's like it can not only the data but also the IP and everything else can be damaged at a very high scale. Then comes the malware attacks, which is another common attack which can disrupt not only the network and all, but it can access all your confidential information both on the business as well as the personal system front. And the malwares can be programmed. There are tools which are available which can also delete some of those valuable information which are there. So imagine the amount of disruption that can cause and the business that can get affected. Uh, the most common form of malwares that we are looking out here is also the ransomware and all this kind of stuff, which is we've been reading about it on a daily basis now, how damaging it has been and how it's been taking most of the banking industry, the e-commerce, the financial sectors, everything else on the ransom point, just by taking away the data. In fact, one of the advancement that happened during the cyber war was they've come up with a malware called whispering malware, which the malware is designed to behave like a ransomware, but it lacked a ransom recovery mechanism, and it rather makes the machines inoperable, and then it starts demanding rather than demanding the ransoms and all that stuff. So it simply makes your machine inoperable. So, and this is slowly these all trends that we can see in the cyber war are slowly moving into the corporate world as well. So this is very scary, and a situation where everything is going on to a level where cyber security, securing your systems and all that stuff has become so prominent. And then there are also these other malwares like the scareware, the skin lockers. All those are some of those common malwares which are there. We also seen some alarming increase in the cyber attacks like the MITM attacks, which it refers to a breach where it's more or less called the man in the middle types of attacks, where eavesdropping takes place when you're trying to share the data between two people or networks or computer. So this is also something which is very damaging when it comes to your data transmission, your business data, your official data that is there sitting on your server, your confidential information, your trade secrets. All these things are at the stake when it comes to some of these attacks that we are talking about. The DOS and DDoS attacks have been there for quite some time, but now they are also increasing at a very alarming rate. We saw so many increase in these numbers as well. And we have those others, IoT hacking as well. The Internet of Things has also brought in so many new, it has opened so much of paradigm when it comes to the data repositories are concerned. But as data is valuable, and for that the hackers will look to exploit any of those standard devices which are there. The more things we connect, it becomes more juicier for the hackers to get into the systems and then hack into your data and all those kind of things. So Gauri, these are some of those the attacks that we are facing, we are experiencing it, whether it's an SQL injection attack or whether it's a IoT hack kind of stuff. These are going to be keep on increasing, day by day.
Sure. So thanks, Milind, for that, and and thanks for explaining it, in so much sort of detail for the audience, because what you have also realized as we sort of especially when the not only the digital companies, because traditionally we saw that it is the digital businesses, it's not only the digital businesses which are online now, but everybody is getting online. when
Correct.
everybody is getting connected, as you mentioned, whether it is manufacturing sites,
Correct.
all of that now is interconnected, right?
Correct.
So obviously the awareness, and we'll come to that at the end of the session in terms of awareness and the work that is required in this space. But I think let's move to Anirudh. Why don't you sort of give a quick difference between what we had under 2013 rules and where do you see the direction, sort of uh, putting additional burden in terms of the compliance when it comes to reporting of cyber incidences. And just for the audience, there are three different definitions. First of all, the act doesn't define cyber incidents, it is there in the rules. So cyber incidents, cyber security incidents, so let's not get into those technicalities. Let us assume that it's a breach of the network. Let's keep it simple for the purpose of this webinar, but there are technicalities about the definitions also. But let's just focus on the broad principle. And Anirudh, if you can just explain the difference.
Sure, Gauri. So I think it's important to understand that under the rules that were there from 2013, there was still some notification requirements or reporting obligations, and there was an annexure. There is an annexure to that to the rules which have around 10 odd incidents which are mandatorily required to be reported. And even the scope of entities covered under the rules is actually quite broad because it includes all individuals, organization, and even corporate entity. So a similar broad scope also exists as far as entities are concerned in the direction as well. However, uh, I think 10 additional types of incidents have been added, which are mandatorily reportable. And even more critically, the requirement under the rules was to notify as soon as possible. So there was no set timeline that within this much time you have to actually notify if there's an incident. And this is where the direction actually crucially changes that entire requirement because it talks about reporting within 6 hours of noticing a cyber incident, which could be any one or more of the ones which are specified in the annexure. Otherwise, the rules actually do not have a lot of specific compliances that are now provided in the direction. We'll deal with them later during the webinar, I think. Uh, and another important change in the direction is that entities would be required to comply with specific certain directions, specific uh, requests for information, all of these things, but which although were there in the rules, but they have also been reiterated again in the direction. On the certain website, there is actually a format for reporting incidents as well,
Yeah.
and the direction as well as the rules refer to this format. And yeah, so I think that is how I would summarize the main changes as far as reporting requirements are concerned, at least.
Sure. So I think the way we are looking at this, that earlier there were certain mandatory, certain optional reportings. Now, and the reporting, the information that needs to be provided hasn't changed. That remains the same. But Aparna, we have been discussing about this 6 hour thing and the language from the rules to this, noticing and this, that, and the other. So, how do you think, from a practicality perspective, based on our experience that we have seen in the matters that we have handled, how do you perceive that 6 hour thing and, whether it is even feasible?
Right, Gauri. So I think two sort of concerns that come out of this, right? One is, so if we see the language, it says within 6 hours of noticing such incident. So the first in the direction is, what do you mean by noticing such incidents? When do you, what qualifies as noticing the incident, right? Because like you already said, there are only certain types of incidents that could be incidents that fall within the purview of the direction or the rules, which also need to now mandatorily fall within the within annexure A, right? So to even determine if you have had an incident that falls within that definition, it may take a long time. Uh, clients come to us and ask us whether this is a factual situation and whether this is something that is reportable or not. Now, to even internally have all the facts and to figure out if you have to reach out to someone else to try to determine if it's a reportable offense incident or not, that itself could take a long time. So, is the reporting happening after within 6 hours of noticing and establishing that you have an incident, or does it have to happen within 6 hours of the first time someone in your system tells you, or someone figures out, gets a sense, or gets a even a doubt that an incident has happened? So that clarity right now is not there. Secondly, obviously the issue is the 6 hour, the 6 hour timeline. Even after you've determined that yes, it's an issue, if that's the intent, or the first time you notice, someone tells you that okay, there may be something that has happened, uh, within 6 hours is a very difficult requirement to comply with, considering the fact, as Anirudh said, there is a form which you need to fill to report your incident, and the form in fact asks you to provide several different types of information. Now within 6 hours you may not have, entities may not have all that information, so that becomes a little bit of a challenge. A lot of times what also we have seen is that this is a concern that we've been hearing a lot, that sometimes internally you may get a doubt, there may be a doubt that okay, this is something that okay, there is a cybersecurity issue, but you will do some investigation and you'll figure out okay, no, this is not an issue. Now, the thing that will happen because of all this, and the concern actually is that the most entities now, to sort of ensure that they're in compliance, because there are now serious consequences which we'll discuss later in case you're not complying with the reporting requirement. Now the entities would probably just do a data dump. They will not have time to even figure out what all they need to provide. They will just dump data with certain. Now, because of that, certain actually needs to ensure that there's manpower, and their own security practices are there's nothing goes wrong there, which I'm sure is the case. But this some concerns that we are hearing. So these are things, because of the data dump, issues that may be bigger issues, that may be really concerning issues, could just go unnoticed because there's so many entities now um, now reporting, right? Especially some of the things that are now included in Annexure A. For instance, there is one which requires you to report unauthorized access to secure social media accounts. Now that's something which could happen almost on the daily basis with bigger social media platforms. So if things like that are being reported on a regular basis, when there's a bigger issue that happens, that it may just get unnoticed. So yeah, I think those are some of the concerns with this one.
No, completely agree. And since you mentioned annexure, that has been provided, let's understand what is the purpose of 70B. 70B purpose is essentially the security of the network overall, right? Now, if you simplicity say data breach, that is the entry, right? Now, data breach could happen because of external, attack, or it could happen even from internal, correct? So obviously, if it is internal, that is not really the concern of the government, right? It is my internal security issue in terms of my employee or otherwise. So I think, the expanse of the items that have been provided, just to give an example, even the first entry, right, which mentions about, uh, the probing. Now probing, it could be simply, firewall is getting knocked. Now firewalls maybe getting knocked so many times, but the breach hasn't happened. So that means you now need to report each and every suspicion of an attack as well. And then, what is the purpose of all this? I can understand that if you need help of certain, and if certain were to provide you help, and certain says, if you want my help to help you resolve, right, then you need to approach me within 6 hours, because that is the window where we can really help. That is different than simply saying give me everything, right, with a suspicion as well. I think that is where we feel that it is going way beyond. And ultimately, in a cyber world, there are so many situations occurring. So probably even a harm based approach, that really is something that requires an action which is an immediate action, versus something the organizations can take care of themselves, and then maybe there is a reporting obligation. But in other jurisdictions, we have seen it is more of criticality based reporting than just a minor thing here and there, which is likely to happen uh, on a regular basis, which is not really impacting the network, right? Just as I said, firewall attack, right? But the infiltration hasn't happened. So I think with that, I think so these are the concerns from a reporting as to the expanse that we have noticed. Let's move on, the item number one in the direction, which is with respect to the timestamp, right? That we need for the purpose of reporting. I think this is, this provision has been inserted more from a, when you are reporting something, uh, what is the time of the incidents when you're reporting? When I say time, at what time it has occurred? I think to get that accurate information, this provision of connectivity to the network time protocol, has been provided. So, Milind, if you can just explain what is expected and how we are looking at this provision, from a practical perspective.
Yeah, so I'll try to make it sound a little bit less complicated. So basically, so time synchronization, right? Now, obviously, we're talking from the point of view of this cybersecurity aspect. So the computer obviously depends on a time for a lot of reasons. But when it comes to cybersecurity, it has to be synced across systems, which can help us in incident reporting and all this kind of stuff. Because the first thing that an attacker will do after he attacks your system is try to clear all their tracks, and then one way that you do that is by fiddling around with the clock time, so your logs go astray, and then you don't have proper logs, when the forensic investigation comes into the picture, and becomes very difficult. So basically they have to be connected to a time server. Now there are to have all the systems connected to an accurate time server, they have to be connected to a GPS. So there is this GPS satellite system which are there, where many of the servers we connect to it. But then every time, not necessary that due to the lag, due to this what time server, which where exactly you are sitting, and if the time server is down and all this kind of stuff, you also, that's the main purpose why the NTP protocol comes into the picture, to minimize the time drift that can happen due to this lagging issues. Now, what certain wants to do is, it says it wants companies to connect to the network time protocol server of the National Informatics Center, that is NIC, or the National Physical Laboratory, NPL, or to servers traceable to these NTP servers for synchronizations of their system clocks. Now, those entities with infrastructure spanning multiple geographies can use any other accurate sources, as far as the time source does not deviate from the NPL and NIC is concerned. Now, let's say, for example, if I am somebody who's not into this geography, and I'm running a data center. Now, when I'm talking about some data centers, we're talking about a lot of machines over there. And then the first thought which will come to my mind is, why would somebody connect to an NPL or an NIC server which is located at the other end, and not something which is located, which is absolutely nearby to me? So the most important factor here that counts is the latency, because the more further you go for connecting your servers, the more you increase your latency time period. So obviously here, when you talk about synchronizing the time and connecting to the servers is concerned, even the nanoseconds and the milliseconds matter a lot. So there are so many of this technology which are already there, such as something called Anycast, to reduce latency and all that stuff, which is actually being used to make this less complicated by the the people who run the data centers and all that stuff. Because by building geographically and all those things, so having connecting, if it is made, if they make it mandatory to connect only to the NIC and NPL servers, the latency is something which we have to keep it in mind, so that there is no lag in the connectivity. Second thing that also comes is, if we don't have any standard servers which has yet been declared. So the amount of connectivity, we assume that there are those numbered NIC and NLP servers to which we have to connect. So imagine the amount of connectivity that will be established. It will be like overwhelming to get connected to those servers, and we really don't know how the things will run on that front. When it comes to the accuracy and all those kind of things. And the last but not the least stuff is when we'll be connecting to the servers, we don't know how the privacy part will also be will be handled. So maybe one way of looking at this is if they can have only those cloud platforms which can connect to the to those dedicated NTP servers, preferably with a single standard time source or something like that, where they can start synchronizing the time with them, and also have some authorized servers at the other ends where we continue to connect to those servers which we have always been, so that it can correlate the logs. The distant log sets also can be synchronized. And there are also, like I said, a lot of these tools which are available right now to make sure that the lag and the latency is taken care of. So Gauri, that's what I feel when it comes to the time and NTP protocol and NLC servers is concerned. It can be addressed, to take care of all these latency issues when it comes to geographies and all those things.
Right, right. So I think the other thing you mentioned is multi-geography, based entities, right? I think what I understand the expectation could be, and that hopefully can come out in FAQ, is that whether, they can have their own time, so long as they are able to tell us the difference, between the Indian time and their network time, right? So I think that is could be the expectation from the reporting perspective. But as I said, all this will need to evolve as we go along in terms of clarity on some of the practical implementation, of the direction. One is to simply put something in the direction, and the other is how, we are able to implement that. So the same question, when I say, there is item number 4 in the direction, which again I'll need to come back to you, Milind, to explain as a technical person, forget, from a legal perspective or otherwise, which we ourselves are confused. But the wording, it says, the organizations shall mandatorily enable logs of all their ICT system, right? We'll come to the localization in a bit, or the time period and all that in a bit. But how do you even interpret this logs of all their ICT systems? So if you have to look at that, what is the universe of the logs that we are really talking about?
Yeah, so Gauri, when it comes to the log reporting, right? So first of all, there are some, I would say, humongous logs which are actually which SN, from the system's point of view, we start capturing. So basically, it's all the timestamp documentation of events relevant to a particular system, which can come into the log per se. And it's not only the whether it's a firewall or the switch or all those kind of stuff. There are many software applications, many server applications which might be producing these log files. So like, for example, if I give you some examples, like if I'm talking about a web server, right? From the server's log file, there is an administrator can identify a number of visitors who are coming, the domains from where they are visiting, the number of requests for each of these pages, the usage patterns that is going according to the variables with that. So all these timestamp is something that we start recording, right? Whether it's a email servers, then we are talking about the database to which it is connecting. So the kind of information that we are uh, today maintaining when the logs are concerned, it's humongous, right? And then basically what the CERT is talking about is, that companies must mandatorily enable logs for rolling 180 days is what they are talking about, and which should be which should be provided to certain along with the reporting of the incident whenever an incident takes place. So here, first of all, here there is no scope which is defined when it comes to the logs. because they haven't defined whether what are the devices,
Right.
exactly. And here we are talking about, I mean, trust me, today, if you ask me, how much is the amount of logs that you must be maintaining per day? If I talk about a small organization, there won't be less than 1 TB, 2 TB of data per day, which we're talking about when it comes to the logs,
Right.
and storing that data. So you're getting again into some another pitfall when it comes to the security of the storage of those data. So here you're also talking about some, financial stress on the company, obviously, because you have to again provide that many repositories to store the data. You have to make sure that it is completely secured. If not in your own data centers, if you're talking about a cloud, then you have to manage the cloud repositories for maintaining that kind of a data. Once again, when we talk about submitting that information to CERT, right, we don't know how exactly how we are going to be transmitting that kind of a that huge data. So, since the scope is also not defined, it's simply said that logs have to be maintained. It's practically very difficult for any organization to start maintaining the logs, because it's a simple website can have so many pieces of small bits of information when it comes to the software running on those website or applications or databases. And then we're talking about those logs which are created every second. So it's
Right.
like a crazy amount of data that we are talking about. So it would have been, and also next question is, we don't know how does the privacy of that information then goes about, right? Because when we talk about logs, there may be so much of PII kind of information which might be getting captured in the logs, and how do you filter it out? How do you maintain that? So it's a vast domain that we are getting into. Maybe it would have been much easier if they would have carved out what are the specific critical devices logs which should be maintained, or those critical logs which should be maintained with respect to those incidents, might be a better approach in handling things, rather than getting the entire log collection into this picture.
No, couldn't agree with you more, Milind. Sorry, were you saying something?
No.
Yeah.
That's all from me.
No, I think two, three important points so that, sort of let's understand, that what you're talking about. Number one, if I understood you correctly, what is the purpose of all this is the security breach reporting. So not
Correct.
all logs relate to that. Number one,
Correct.
correct? So
Correct.
one could have said that only the security, say maybe firewall or maybe router based or whatever, just identify some specifics
Correct.
from logs perspective. And secondly, I completely agree that, when you're maintaining so much information at one place, that itself is a, sort of field, for the hackers, right? When they will know
Absolutely.
that each organization is going to maintain this information.
Absolutely.
And I
Absolutely.
think the other quick question I had for Milind for you is, this 180-day period, right?
Correct.
So could
Correct.
you
Correct.
just explain typically organizations, whatever logs they maintain as a general practice, what is a general practice of maintenance?
See, honestly, if it's a small organization, we normally go up to 1 month, 2 months of logs, which can
Right,
then, keep it
right,
under control. Here we are talking
right.
about 180 days, which is
6 months.
around
Yeah,
6 months,
correct, correct.
which is a
So
long
that
period.
itself is an huge impact in our view. So I think if so, if this is a feedback probably to be taken to the government, if they could narrow down the nature of the logs, and also the duration, because ultimately it's not forever that you need this information. It's for the purpose of dealing with the security, that incident, right? So to that extent, to the extent required, you will maintain for that period, right? And of course, the bigger elephant in the room is the localization, which somehow you are noticing in all the regulations, this requirement of secure maintaining the logs in India, right? So I think that is the other piece. We can keep talking forever about why localization is not a good idea, etc. But I think let's leave that, because that's much larger conversation, for several industries. And but if you have any quick comment on this particular piece from a security perspective, Milind, quickly to you on this localization aspect.
See, obviously, because see, when it comes to maintaining the logs, the utmost priority is the security of those logs, right? Because, like you said, if you start dumping those logs, storing those logs, you are again sitting on a ticking bomb, because just like it's as good as having your own live data, most critical, crucial data, because first of all, you're protecting your data against those threats, attacks, hackers.
Right.
And then if you're sitting again on this log repository, you have to maintain a separate server for it. Like I said, either it can be on the cloud or it can be in your own data center. So it's again a different domain which you're getting into when it comes to the security,
Right. Right. So I think, having dealt with the logs issue, I think let's move on to the next point, which is the maintenance of certain information, which is under your, direction 3, right? And also, provision of the information to certain. And Aparna, we examine the difference. If you want to just play out as to how the rules, what did the rules expect? Because thus far nobody for 8 years has complained about the rules. Even if probably people have not paid so much attention to, or maybe it was not even implemented to the extent till now. But generally, on the face of it, what is the difference? And whether you find, your comment on, excessiveness or proportionality or otherwise on this.
Right. So actually, if you see the way the rules are worded, there are certain very broad powers under the rules also, uh, and some of them are now captured under this direction 3. So I'll just first deal with what the rules say. Now there is a rule 13 which says that certain could have sought information in relation to cybersecurity incidents from any entity. So while in the rules the information seeking power was limited to cybersecurity incidents that have occurred. Now, the direction, however, says that information, the way 3 reads, is that by way of an order or a direction, certain can either ask entities to take action or ask entities to provide information for the purpose of cybersecurity incidents or even protective and preventive actions. So this is where I think there's a little bit of a concern that we have been seeing, that now it's not just in relation to cybersecurity incidents that have happened, but it could be also any protective preventive actions which could, which according to certain could be something that needs to be done. They can ask for any information, and also the scope of information that could be sought is not really clarified, right? It could be they could ask for any information and you need to provide it. One more rule which is relevant, which was already there, and again, like you said, is not something that that anyone sort of ever spoke about, is rule 15, which also actually already said that for the purpose of enhancing cybersecurity in the country, certain could issue any direction or advisories, and entities were required to comply with that. So while already there were certain broad powers, the way 3 now talks about, that they could seek any information for protective preventive measures, there is a little bit more of it's a little broader than what was already covered, and that's why there's a little bit of a concern here.
Sure. And I think let's Aparna also talk about, think about the fact that 2013, quite a few things have sort of moved since then. You had Puttaswamy coming in at 2017, right? And the other doctrines that have got established in terms of proportionality, etc. as well, right? So I feel that somewhere even 2013 rules could be looked at in that with that lens, right? Because what you're seeking to do versus what harm you're trying to sort of protect against, right? Is it even is it because what Milind said, what you said, it seems as if there is possibility. I'm not saying it will happen, but you are just opening that entire gate for surveillance, right? And when you have so today it may not be happening, but it's a a possibility of the surveillance under these rules, you can't really negate. As I said, it may not be happening, but you are sort of creating that sort of fear in the minds of members, which also is from a doing ease of doing business kind of story, etc. It's not giving a clear picture. First of all, it creates, as we always talk from a legal perspective, is arbitrariness, right? Because the fundamental thing is when the law is vague, it leads to arbitrariness, and then thereby violation of article 14, right? If you just see the entire chain of the legal argument, right? So somewhere I feel this appears to be very vague, broad, and therefore likely to lead to arbitrariness, surveillance, disproportionate exercise of power, etc., etc. So all possible arguments I feel one can take under this. But I think one other aspect which get sort of not in covered in the direction which is very important is all the information that Milind and you spoke about in terms of when CERT collects that information, what is the security of that information, how is will that be shared onwards. So Anirudh, if you can just explain what do the rules say vis-a-vis the information collected by certain, right, in this entire process, and the security of the information sitting with them.
Right. So Rule 13 of the certain rules actually provides for the obligations on certain to maintain confidentiality of whatever information it receives. Because I think that at some stage or at some level, there is a recognition of the fact that certain will have access to huge data sets, to a lot of sensitive information, which is why through the rules itself, confidentiality obligations have been imposed on certain. So to summarize what kind of restrictions actually apply, certain has to comply with one, applicable legal restrictions, second, order of competent Indian courts, third, ethical practices, and apart from all of this, they also need to maintain reasonable controls and internal checks to maintain confidentiality. So they are basically required to comply with all of these requirements, and it's not an or sort of provision, it's an and provision. And apart from that, there's an express provision which says that unless certain has the consent of the person disclosing the information or the of the entity disclosing the information or the entity being impacted, or there is an order of a competent court, certain cannot actually disclose the identity of the individual or the organization which has been impacted or which is even disclosing or reporting such incidents. So the only exception they have been provided is basically that they can provide metadata, basically trends of general cyber security incidents for creating awareness amongst people. And additionally, they can also, if it is necessary or expedient to do so, uh, on the basis of certain grounds. So these grounds are similar to those that we find under, let's say, Article 19.2. So basically, sovereignty, security of the state, public order, and one additional one is enhancing cybersecurity. So these are also some grounds on which certain may disclose only the relevant information to stakeholders. So it's not like a blanket sort of power where certain can disclose whatever it wants. It needs to be on these grounds and it needs to be only the relevant information. So yeah, while certain will have access to a lot of uh, sensitive information, they also need to take care that they maintain confidentiality, they maintain anonymity of the entities involved. And these are all under the rules. So as Gauri mentioned, the directions are actually not really dealing with all of this.
Right, right. So of course, I think there was a question which I'll quickly take. I think on the direction not being gazetted, etc. So as I said at the beginning of the webinar, this direction is not really something under the act requires to be gazetted. The manner in which the rules are required to be gazetted, right? And even the parliamentary scrutiny that is expected under the act. And in our view, the direction, the way we were looking at the provision, though it is quite vague and can be all expansive, but it was not meant to be in the nature of general direction the way it is come out. It probably was meant in the context of specific incidents that may have happened, and in relation to that, because if you really see the the latter part of the rules which also talk about the liability, it appears a little odd that certain is actually going on to sort of at an executive level take the position of a rule making power, right? So that is where, just to repeat, our concern is, and you're right that the direction as such, at least our reading suggests that it doesn't require to get, sort of gazetted or notified. So I think let's move quickly, taking consideration the time, and we do have other questions to answer, which we will. Let's move on to quickly the item number 5 and 6, which I think has sort of created a lot of anxiety among the stakeholders. We even saw some articles coming out, against these provisions. So, Anirudh, again back to you. Why don't you explain what is an expectation vis-a-vis, some of the specific service providers that is expected under the rules, and your view as to how, I mean, our sort of comments on these requirements.
Sure. So actually, there are four types of entities which are mentioned under item 5, and these have not been defined. So Milind can always help us out here. So these entities are actually data centers, virtual private server providers, cloud service providers, and virtual private network or VPN service providers. The obligation with them is primarily to register certain information, and this information is also qualified as being accurate. So while we come to the types of information that needs to be recorded, I think what needs to be really emphasized here is that this information needs to be accurate, which somehow implies that it is the responsibility of these service providers to collect information, to verify the information, and of course to also maintain it for a period of 5 years or even longer if that's what is mandated by the law. And even the kind of information that they are supposed to collect is quite broad. There are around 7 heads of information which need to be collected, and this includes validated names, period of hire, and some surprising ones such as purpose for hiring services and the ownership pattern of the subscribers and customers which are hiring services. So when we read the heads of information that need to be collected, this seems more like a KYC sort of requirement that is also there under provision 6 of the direction. But largely, I think what could be a little concerning to these service providers is how do they really uh, ensure that this information is accurate? How do they really collect such broad information? Whether collecting all of this information really serves a purpose. So these are, I think, some issues which the industry would be grappling with. Yeah.
Sure. So I think, you're right. These are actually in the nature of KYC, and whether I keep going back, whether it was even warranted, under the direction heading, where such, sort of overarching, requirement is introduced, as a part of direction. And I think even this 5 year and all of this, right, again, it's quite going back to the surveillance aspect, right? Now, for example, if I you mentioned the purpose, right, I may change the purpose in between. How do I even ensure, as a cloud service provider, the accuracy? So that means you need to have the ability to have, digital KYC in the country, a solid framework for that, right? Because it's different from a regulated entity, which is like banking companies, or regulated entities, to be required to take the KYC, and the certain methodology which are being developed for them, for that KYC, versus these unregulated entities, requiring to do these things, right? So, Milind, do you have any specific feedback on this provision?
So I mean, the only thing that I look at it is if you start asking the VPN providers to submit the information, right? The logs and all that things. It's going to be a very dicey kind of a situation, because there are many organizations who go for these third-party VPN services so that their entire information that they connect to and share and all that stuff remains confidential, and the privacy is maintained. Now, if you are going to be if that has to be provided, that means all these remote machines, all these businesses which are connecting on the private platforms, on the virtual private networks, even their information has to be it'll get logged into their system. So the big question is, why would then somebody like to go for this kind of a VPN services? So that's the only part which is very alarming.
Sure, sure. So I think the next interesting one is where, there has been so much discussion about crypto exchanges requiring to do certain things, whether there should be a law, there should not be a law, what should be the nature of that law, Whilst all these debates are going on, we are noticing different regulations coming and trying to sort of one way or the other control them. You saw the Finance Act taxing them, and now you have this sudden direction coming after them in terms of KYC, which I understand that some of the exchanges which are part of self-regulatory bodies were already doing some amount of KYC as a part of their self-regulation. But Aparna, could you just explain on this particular thing, especially from a definitional context, right? How because they do refer to the Finance Act. So, any thoughts on the requirements?
Yeah, sure. So let me just first just tell everyone what the requirement is, and then we'll come to the discussion on the types of entities. So first, it's applicable to the entities mentioned are virtual asset service providers, virtual asset exchange providers, and custodian wallet providers. And the obligation is to maintain all KYC information and all information related to financial transactions for a period of 5 years. So that's the obligation. Now, coming to the point about what they've said about this type of entities, right? So they've said the direction is applicable to these entities which I just mentioned as defined by Ministry of Finance. Now, actually, till date, none of these terms that they've used is defined. Like you mentioned, Gauri, recently the definition was added in the Income Tax Act for virtual digital assets. So even that specifically doesn't really cover exactly what they're talking about here. And if you would just think about the types of entities that could be covered, right? Now coming to the basically the concerns that we are hearing with this one. Uh, the types of entities that could be covered. Obviously, there are crypto exchanges. There are other entities that are already regulated in the under other laws who are already maintaining certain KYC information for a certain period of years. But there could be, if you think about what virtual asset service providers could cover, it could cover entities that are providing loyalty programs, say loyalty points, or gaming operators, gaming platforms where where when you're playing a game, there's certain items that you win in a game, right? So could those be considered virtual assets? Now, these are entities which are currently unregulated in terms of at least a KYC that they need to do. So are these entities now also required to, reconsider the way they are they're handling their registrations of users onboarding onto these platforms, or the way they're recording their financial transactions? So that's one sort of consideration here. The other one is, it says you have to maintain information of all financial transactions. It has to be the information has to be accurate. So like Anirudh said earlier, you have to ensure, I mean, this is a KYC requirement. You need to ensure that you are verifying everything, all the information that is being collected. And there is also language in the direction saying it has to be done in a way that it can be restructured along with relevant elements, and which are mentioned in the direction, right? So it's a little, the way these entities may be currently, sort of recording information may not be what the direction requires. And that's where I think the concern also comes in, that now entities need to sort of reconsider the way they've been doing their business, and now collect information in the manner that the direction requires them to do.
Sure. So I think even in the Finance Act, when we saw the definition of virtual digital assets, there was always this confusion as to, is it only the assets that get created by cryptographic means, or in and any other way. So whether that any other way or whatever that language is to be interpreted in a similar technology or anything and everything as the loyalty points that you mentioned, right? Which will be really, sort of out there, sort of, which doesn't appear, hopefully, the intention, but they were going to define NFT separately and all of that, right? So I think the interplay between the Finance Act and how things develop there. But now, within 60 days, if these people have to comply, right, up from the date of the direction. So I think even that 60-day period to figure things out, because it's not that you can just start doing all these requirements overnight. You need changes in your systems, processes. You need testing whether your processes are working, right? So some amount of, if at all, these directions are not taken back, or they are supposed to be continued, even that 60-day period to what all you mentioned may not be sufficient, because in terms of compliance. So I think with that we are sort of done with the provisions in the rules, but I just want to call out a certain sort of expectation when we are looking at some of these developments from a cybersecurity incidents reporting perspective. I think honestly, as practitioners, right from 2013, though the rules are in effect, we see from awareness perspective, very little awareness amongst the Indian, enterprises about the requirement of reporting. I don't even know whether they're even tracking, the incidences. For example, in one of the recent matters we were handling, the entity wasn't even aware as to how do we even unearth whether the incidence has taken place, right? So that is unfortunately the lack of awareness in the system, right? So I think before coming out with such overarching direction, what ideally could have helped is, as we saw in, Rule 4, which is the white, coming out with the white papers and, all the awareness campaign that is required. If certain can take, specific steps and very, very aggressive steps in, creating that awareness campaign in the, in the among the enterprises in the country, so that at least people are aware, and then create specific SOPs. Because it is one thing to simply say that do this, do that, but if you have SOPs in place to say that, okay, this is the manner in which you have to do periodic audit, these are the system requirements, this is the manner in which things can, so it's some hand holding. If certain can also exercise that, sort of diligence in terms of providing the hand holding to the industry, I think that will also go a long way. Because as I started in the beginning, that nobody is undermining the importance of the cybersecurity, in the country, especially, in the context of what Milind explained, what happened over last 2 years and what continues to happen. Nobody is undermining that. But if the entire ecosystem is created in a manner where there is awareness, and then an expectation of reporting, because now what is going to happen is there is going to be a total chaos in the market, because people don't know what to do, and then you have a liability sitting on there, right? So I think I would also want Aparna to briefly explain, since we have now discussed, the directions and the impact. Maybe Aparna, you want to explain, if at all the directions are not complied, or who is not complied, how are the implications of liability perspective? What is the process that a certain may follow in case the direction? So one is the rules not being implemented, and then there is a direction not being implemented. And interestingly, you have different consequences for both, right? So you want to just explain that?
Sure. So actually, if you see the way the rules, the certain rules, there's nothing that in the rules that says what is the consequence of non-compliance with the certain with the reporting requirement in the rules. There is a section which talks about non-compliance with any direction that certain issues, but there's nothing that talks about what happens if you don't comply with the mandatory reporting requirement. So for that, the answer as to what would be the penalty, according to us, would lie under Section 45 of the IT Act, which provides which is a residuary provision basically, which deals with the penalties that are applicable in case there's no specific penalty provided for under the law. So there actually the amount is around 25,000 only for in case there is a in case there's a violation or a non-compliance that's otherwise not discussed in the rules, in the act, or and in our case in the rules, right? But the way now the direction deals with non-compliance, the direction specifically says that failure to furnish information or non-compliance with the direction may invite punitive action under section 70B and subsection 7. What this subsection 7 basically says of the IT, and this is subsection 70B of the IT Act. This subsection 7 basically says that in case of non-compliance of any direction, the entity that's not in non-compliance could be punished with imprisonment of up to 1 year or with a fine of up to 1 lakh. So now the issue that has basically happened is that while if you don't report as per the rules, there is no it's at least there's no imprisonment, and the financial penalty is also considerably low. However, now if because the reporting requirement comes under the direction, the if you don't comply with the direction, that is if you don't report in within 6 hours as per the direction, you're not in you're non-compliant with the direction itself, which could result in the penalty as provided under subsection 7 here, which is on screen right now. Just very quickly dealing with how this actually will play out, certain rules also provide the manner in which non-compliance of directions has to be dealt with. So it's not a direct situation where, for instance, tomorrow I as an individual, as a private person, figure out that okay, some entity has not complied with the direction, and I make a complaint and post that there could be imprisonment or a fine. The way now, which is on screen, the way non-compliance has to be dealt with is that the director general has to basically make a report of there has to be a report of non-compliance to be made by the relevant officer to the director general. Post this, there is a review committee to which this report of non-compliance goes. The review committee also looks at it and figures out if there is a non-compliance. Post that, the review committee will issue a direction to the relevant officer saying, okay, now you can proceed under subsection 7 of the Act. And that's how the procedure of non-compliance is to be dealt with. So while there is a consequence, a serious consequence, there is an entire manner in which it will be dealt with under the rules.
Right. Thanks, Aparna. And there is some amount of overlap, and a fine reading is required as to what exactly is getting not complied with, and the interplay between that Rule 19 and all of that in the rules, as well as a Section 70B. I think let me just quickly take a couple of questions for next 5 minutes, and thanks for posing these questions. So from a bank perspective, it's an important question, because if you really see the definition or the wording of basically the main section, the rules, and the direction in our mind would include banks, because it simply says service providers and the like. It doesn't give you those definitions. So obviously it will come into play. The question really is foreign bank versus Indian bank and the like. I think what we really need to understand is from an extraterritorial applicability perspective, right? It's a little complicated situation, and we have by the facts of each case. But as a broad principle, we need to see whether a computer in India is involved in the incidents, to put it very simply, right? So, for example, if a network in India is getting affected, that is one of the important, or a computer in India is involved in that particular incident, is something we need to examine. And one other interesting important point that to note is that this is not a data protection law. This is a security related law, right? I mean, when I say law, I'm referring to the provision. So it is not relating to the data breach, or when I say data breach from a jurisdiction perspective, if by the logic I explained, and this is don't sort of, this is not legal advice, let me put that disclaimer. But if otherwise you're not getting covered under the aegis of the act by this extraterritorial applicability vis-a-vis the computer involved in the country, etc. But if there is a otherwise there is no trigger, and if the Indian data is breached in the foreign territory, there could be an argument that this reporting may not get triggered. Now we need to wait and watch how generally it is understood by in government's mind, but that is our interpretation of the overall situation. And again, it's not as easy, because whatever cases we have handled, there is always a network diagram we have to examine. We need to examine how the computers are interconnected, etc., right? So we need to do a factual examination of the situation, and only then we take a call in terms of the trigger. I think what happens after your breach, is there a scenario where certain helps? Yeah, so the expectation is that certain is supposed to help. That's the whole purpose of this. If you see, subsection 4 of section 70B also, there is an expectation that certain is going to help you to sort of address that security incidents or mitigate that security incidents. And that is why we have been saying that if certain is expected to help, they need to be it has to be risk based and criticality based, because it is going to be humanly impossible to address each and every incident that we come across. But yes, I hope that answers your question. Then there was a question on the privacy, which I think Milind already answered, that yes, in our mind, the amount of data that is expected to be maintained and saved, it could lead to privacy concerns, because now the hackers are aware that, hey, each of these organizations will be maintaining this amount of data with them and for such a period of time. So obviously, there is a concern in our mind. And of course, when I say concern, everybody will handle security. People will try to save that, secured manner. But just the fact that so much data is available at one place itself, is an issue, because what I understand, especially in the localization context, sometimes what you try to do is split the data at different places, so one is not able to sort of make two and put two and two together. You sometimes have that, and maybe Milind, you can come in here. I think there are some of these processes which you try to adopt. But yes, if that is not done, there is a concern. Milind, I'm just going to check, and Aparna, if you can check if I missed any other question. But Milind, do you want to quickly address this privacy just one more time for the question?
So yeah, basically, I think if you're sitting on this data, right, then obviously then you'll have to make sure that the data which you have, that is properly encrypted, then the encryption is run on all the repositories where you're maintaining the data. Then, obviously when you have the logs and all that stuff, we always make a backup of these logs also, because you don't want to sit on only one copy of it. If tomorrow anything happens, then you have to make sure that both the copies are encrypted. But then it all depends upon how these things will progress further. So accordingly, then this can be addressed, and whether it has to be, we have to maintain it on DDR sites and all those kind of things. Everything else will come in picture if this is, enforced. So that is something we'll have to look forward to.
Right, and I think even from a depending upon the clarity that we get in the logs, right? I think even from a data protection, though we don't have that law in place thus far, but overall, is even if, for example, notice and consent, right? Because if you end up collecting so much of private information, if at all, in these logs, then you need to give that notice, because for my purpose, I'm technically not required. So for my, for providing the service, I may not necessarily need all the logs of a customer of their, you know, uh, of their activity in in my network, right? I may not be saving all of that, but the moment I end up start saving that, I need to give notice, as a concept, right? So I think some of these interplay between the data protection and privacy law and this, we will need to see how it develops. But I think we have taken most of the questions now. So if there are no further questions, we will sort of
Gauri, I can just answer the
yeah, there's
second
one
part
additional
of
question. Yeah.
and second part of Pooja's question, which says, can certain punish the offender on its own accord? So currently, there's no the law. Indian law is not like that. While in certain other countries, in fact, the relevant agencies which investigate cybersecurity incidents could have such powers. Certain itself doesn't have the power to punish an offender. Certain role is limited to investigating an offense and sort of issuing directions either to the entity affected or generally to ensure that there's no further such issues that happen. But some of the provisions we discuss, it could be a situation where, say, a court directs certain to disclose certain information to the relevant law enforcement agencies to assist them to, nab the relevant offender. So that could happen, but certain itself cannot take that action, at least under the rules and the act right now.
Sure. I think while we were answering questions, some additional questions have come in. And this interesting question, which I alluded to earlier also, if you see, it says, does unauthorized access of IT system data include employee who legitimately have access but exceeded the authority? So this is exactly the point I was mentioning before, that when you say data breach, right? If my own employees have breached the data, right? Technically, that is from a cyber security, from a risk perspective, that is my internal matter technically, right? So I need not get covered under this, but the manner in which now your annexure reads, it simply says data breach. So one approach is that I look at this annexure in consonance with the definition of cyber incident, to say that if it is not cyber incident, then even if it is data breach which is internal, I don't need to report, right? But the that is one way to interpret, and one argument that I can say, because if you see annexure 1, it says type of cyber security incidences required to be reported. So one can argue that no, internal thing is not really a cyber security incidence, right? So that's the way, because and I feel that that is the way we can handle this situation. I think another interesting question, which again we had alluded to before, was whether only attempts need to be reported. And that's exactly our point, that there will be constant attempts on your firewall, to penetrate your firewall. But that does not necessarily lead, if there is no infiltration that has happened, there is, in our view, we can argue that, from a criticality perspective, that should not be required. Let's not worry about the wording of the law, but I'm just talking practically, right? Ideally, if you, otherwise you will have thousands and thousands of reporting probably every minute, right? So we agree with you that only attempt, unless we feel that it's a critical new way of attack, but because some attacks are already known, right? And that's why the firewalls stop them. Why? Because firewall, I mean, the firewalls are created to address those in those attempts, right? And that is why it remains an attempt, because we already know these type of attacks exist, right? The moment the it's a new type of an attack, there will be infiltration, and then there is a reporting requirement, right? So I'm just thinking practically on this, and Milind, correct me if I'm wrong, but that's the way I'm thinking, because these are already
Yeah,
known way of attacks, and the fact that firewall has been able to stop that, because it's a known attack.
correct. Only thing is that there is a little bit of clarity which is needed on the first point which they have put in the rules, which says targeted scanning, and probing of critical network systems. When they say targeted scanning,
Right.
we are talking about scanning of the ports on the firewalls and other stuff that happens millions, in days. So then what does that, where does the scope lie? I mean, does that mean that whatever scans which are taking place on all those ports, are we supposed to report to that? Are we supposed to maintain, the logs of all those things as well? So that is somewhere that we need to have, and that's where, this statement that do we also need to report attempts, because that's an attempt. You're scanning on your ports
Correct.
to just see whether they can penetrate and all that stuff. So if we interpret in that manner, then the question is that, okay, that means the attempts are also to be reported. which
Right.
ideally doesn't make any sense. So we'll
Right.
have to take some more clarity on those things before.
Absolutely. Absolutely. I think I'll take one quick question. Uh, if there are sub businesses, yes, it is applicable to all businesses. So anything, all the activities basically in your network, it's not limited to like your main business. Anything and everything where there is a uh, your systems are having the logs. That's the way the law reads. That will get included. I think, Milind, if you can take this question, which says, what measures should the cybersecurity companies take apart from collecting accurate information?
See, basically, along with taking accurate information, first of all, they also need to address the privacy part of it. Okay, they need to focus on some micro things like which devices they are interested in taking the information. Either it can be an something where the post the attack they can take those logs from the companies to understand that too. This timeline which they've given, right, 6 hours, even that needs to be addressed, because that's too short a timeline to even collect the logs and submit, because every company themselves, they have their internal incident reporting procedures, and that itself takes few hours to arrive at the conclusion that yes, there is an attack and all those kind of things, because otherwise there'll be so much of unwanted trash which might go to them, which is not relevant at all. So these things, we'll have to, on a broad perspective, they will need to address it, so that the whole perspective of this thing, because if you ask me, per se, I'm happy, because the kind of incidents, the kind of attacks which is going on, there needs to be somebody which needs to come in and address all these issues, right? But then there has to be, it has to be addressed in a manner that it's fruitful for the corporate bodies as well as the organizations. And like, there was one question that will they punish, will there be an offense? Only this awareness itself might be good enough for all those people who are making those attempts, because once they know that there is this body who's been appointed now, who's been looking after all these things, and we need to be wary of that, that itself might reduce this kind of attacks and all those kind of things to some extent. But yeah, on the other side, a lot of clarity needs to be there when implementing such things, because even in Singapore there are so many of these things which has been implemented with those sufficient timeline for the businesses, for the corporate
Right.
bodies to report and all those things.
Sure. I think there are quite a few questions on the extraterritorial applicability when, your servers are outside India. I think I've already dealt with that. But as I said, we need to really look at the network diagram, the manner in which the computers within India get connected to the foreign network. If there is a breach in the foreign network, the impact of that, if any, on the Indian computers. So it's a fact-finding exercise to even figure out whether the reporting requirement gets triggered in the country, right? That's exactly why I started by saying that it's even to assess that, you need to have the all the facts to be able to figure that out. But as I said before, it is not a data breach regulation, so it is not linked to the fact that the Indian data is getting affected. It is linked to the fact that Indian network is getting affected, so or the Indian computer is getting affected, right? So that is, in my mind, the focus. That's the way we should look at this, considering the provisions. But again, as I said, this has not been dealt judicially or otherwise, or there is no guidance that has been provided. But another important aspect which we often get asked, and this is one thing, especially for the global organizations, when there is a multi-jurisdictional breach, right? And they report in one country but not in the other country. What are the repercussions? Because if you see the rules, also 2013 rules, and overall, all these cyber security agencies in each of the country are now exchanging information. So one of the concerns also sometimes that we get asked that, hey, I'm reporting in so and so country. However, we don't believe we need to report in India for XYZ reason, but what if they get information from that another, nodal agency in other country, right? So some of these aspects are also examined from a sensitivity perspective. The other thing is, let us also understand that certain is not just sitting there waiting for the information. Certain itself is collecting a lot of information as per their own mandate, right? so they themselves are aware of some of the attacks that may have happened in your system, because it's a multi-pronged attack which they may have already captured, right? So let us also understand that they will also have the information, and therefore there could be, though we, at least in our experience, we have not seen that much activity, but I think because of the last 2 years, sort of experience, I think you will see probably, and especially looking at this direction, you may see more action from certain. And as I've been, I've always said twice, but I want to, sort of say one more time. Let's not undermine the importance of cybersecurity. So it's extremely important for organizations to pay attention. This has become a board level issue because it is affecting your system, it's affecting your employees, it's affecting your, stakeholders. So it's an absolutely critical aspect to be covered by the organization in terms of taking steps. The only confusion that we are currently struggling is what exact steps. So if we can get that clarity, further clarity from certain in terms of FAQs, SOPs, etc., it will be a good guidance for all of us to move forward in this regard. And as I said, when it's a multi-jurisdictional thing also, what are the sensitivities to keep that in mind and create the SOPs. Each organization, in fact, should have an SOP in place, for these situations, regular audits that are expected by your, security agencies, etc., etc. So I think it's a subject matter. Sorry, there is one interesting question which I will deal with, and then we'll end the webinar. Which question says that to be a good cyber lawyer, IT knowledge, cybersecurity knowledge, cyber forensic, data protection, and IPR are skills to mold. Is that right? And the answer is a big yes, because you must have seen even on this call, on this webinar, how much Milind could bring to the table. And, as I said, he's our go-to person when we deal with these matters, because these are of very, very high-tech nature. So as lawyers also, we need to sort of understand and read a lot in terms of technology, the way it functions, the way networks function. So obviously, it's a must, now for a cybersecurity lawyer to have that knowledge. So with that, thank you all. I think we are ending dot on time. Thank you all for overwhelming participation, and please feel free to send more questions. As I said, we are working with the industry to sort of put in a query or a representation with certain. So most welcome to receive your feedback and suggestions, and would love to have your feedback even on the session. What other aspects would you want us to cover in the in the coming sessions? We may have one more session of this nature once we have more clarity from certain, which we hope to have in the near future. And we will be back with you sooner. Thank you. Have a good evening. And we enjoyed the question answer session as well. Thank you for raising these questions. Have a good evening again. Bye.
Thank you so much. Bye.
Thank you.